Good morning, everyone. I'm Keith Eastland. I'm here this morning to kick off the webinar with my good friend and partner, Patrick Edsenga. I know a few people are still joining, but we want to be respectful of everyone's time and we want to get rolling here. So thank you for joining us. We wanted to take this opportunity to talk about a recent development in terms of employer speech and frankly, it being under attack. And we also thought it'd be a good time to maybe gather the wool for some, just to talk about kind of what's going on out there in the world of union organizing and the labor world in general. What we're seeing from our perspective, dealing with multiple clients, union, non-union, watching what the government is doing here is, we saw that the PRO Act sort of stalled, maybe it's dead in Congress, and now we're starting to see through the NLRB, through agency action, we're starting to see an aggressive approach where, if you ask me, it looks like the NLRB's general counsel is trying to tick off or impose whatever she can from the PRO Act administratively to have the NLRB adopt new rules. So we thought we'd spend a little bit of time this morning. Our goal is to make this about 25, 30 minutes tops, and we'll leave questions at the end. If you shoot us questions while we're speaking, we do have a little Q&A button that we'll monitor, and we'll try to answer those questions either during our short presentation or certainly at the end. So with that, I'm going to turn it over to Patrick, and he's going to kick us off.
Good morning, everyone, and thanks, Keith. So I'm going to talk to you a little bit about what's been going on out there in the world of union organizing before Keith talks to you about more of the NLRB side of things and the legal aspect of this. So what we're seeing in some ways is potentially the perfect storm for union organizing. And what do we mean by that? Well, a lot of things have been going on that would seem to make the environment favorable for union organizing. Among those things, first of all, is the highest level of public support for unions since 1965, according to a Gallup poll anyway, and they test this every year, and we're at the highest level since 1965. 68% of Americans support labor unions, and that is pretty bipartisan, actually. 90% of Democrats, 66% of independents, and even 47% of Republicans, which is a bit unusual. So support for labor unions among the public anyway is on the rise. Haven't seen that translate to membership numbers just yet. They still hover around 9% of the private workforce, but there is growing support for them. So on top of that, you add once in a lifetime, hopefully once in a lifetime pandemic, which thrust frontline workers, essential workers into the spotlight and highlighted their importance. On top of that, you have the election of the self-proclaimed most pro-union president you've ever seen. Democratic control of both houses or both chambers of Congress, which Democrats are typically the champions of labor unions. So you have those things going on. And then on top of that, of course, as you certainly are all aware, you have this increasing demand and labor shortages, which gives workers a whole lot of leverage. And like I said, I don't need to tell you all this. You all understand this well. It's something every single one of the clients we talk to are dealing with. Where can I find workers? It's very difficult, very tight labor market. Inflation is causing wages to rise, but so is just a shortage of workers. So we have all of this going on, which kind of creates the perfect storm for unions to flex their muscles. And we saw that late last year. What the AFL-CIO, which is the big federation of the large labor unions in the country, covering over 10 million workers, he dubbed it Striketober. And you saw strikes at some very large companies, very high profile strikes. Of course, Kellogg had a long strike about 3 months or so. John Deere at the same time had a very long strike. But it's not just those sort of traditional unions and unionized employers. You see walkouts at non-union employers. That happened at Netflix, at Activision. You've seen it in healthcare facilities. So there's been a lot of concerted job actions by employees since the pandemic and since this perfect storm has sort of arisen, because they know it's very difficult to replace them in this market. So more strikes than we've seen in a long time have been happening. And they've been, from the union's perspective and probably from the public's perspective, effective in a lot of ways. They certainly caused a lot of attention. And it's not just the typical stuff you would think about for job actions. You also see job actions for people protesting the mandates that have been put in place and things like that. As you can see here, 3M had a group of employees walk out to protest the mandate. So you see protests kind of across the spectrum, protests about lack of COVID safety protocols, and then protests about, vaccine mandates, and then also the traditional type strikes when a contract's up and negotiations are ongoing. So what does all of this add up to? It adds up to emboldened unions, and understandably so, right? So this is effectively, I think, from union advocates and organizers' perspective, this is the time to shoot their shot, and they are doing it. And we are seeing it at some of the biggest names that you can imagine in the workforce now. Obviously, you all are very likely to be aware that Amazon finally had one of its warehouses organized just a week or so ago. And it's a large warehouse. It's 8,000 employees or so. And you all have seen before, they tried to organize another warehouse, a different union down in Alabama, and lost. There's going to be another election there, courtesy of the NLRB, but this is the first successful election for a union in an Amazon warehouse. And was reading some articles on this, and somebody wrote, and this is probably right, this is, equivalent to General Motors or US Steel back in the 40s, 30s, 40s getting organized. That's the standing that Amazon has in our country today. Everybody knows of it. Almost all of us use it. So the fact that one of their warehouses got organized is a big deal for organized labor. It's created a ton of publicity, and you can bet that they are trying to organize other Amazon warehouses, but also that this will embolden people elsewhere. So you see it at Amazon. You also see it at, again, one of the more ubiquitous brands in the whole country, Starbucks. They're everywhere. And they've started to get organized as well on a store-by-store basis. Currently, 16 stores have organized out of 17 that have voted. So that's quite a good success rate for the union. That's obviously just a sliver of Starbucks stores across the country, but it's significant nonetheless. And there are several more that are actively organizing or scheduled to vote on a union in Starbucks. So we're just seeing a lot more activity on the election front. And so I decided to dig into the numbers a bit. And according to the NLRB, from October 2021 through last month, we've seen just shy of 1,200 petitions filed at the agency seeking a union election. That's up 57% from the same period a year earlier, and it's the highest level in the last 10 years. So it's not just that there's more coverage of this, it's that it's actually happening more. So this is a time that is just absolutely ripe for union organizing. And in some ways, you all are familiar with it, but in some ways, this is a very new and different phenomenon. And why do I say that? Well, I think you look at this picture, right? This is not our fathers and mothers' labor unions. These are different people. They are younger. They don't fit the typical union stereotype that you might think of when you think of a Teamsters or a UAW rep or organizer. These are progressive activists, and very importantly, They are homegrown unions at both this successful Amazon warehouse, the Amazon Labor Union, and also at the Starbucks locations. They are the Starbucks Workers Union. So they are not using the traditional labor unions to organize the Teamsters, UAW, UFCW, steelworkers. They might consult them a little bit, but they are going it their own way. And these are truly worker-led, employer-led efforts. And I think talking about the Amazon one in particular is interesting. So the individual on the left in red with sunglasses, his name is Christian Smalls. He is the one that led this effort. And I listened to a podcast where he was talked to for an hour about this last night, and it's extremely interesting how he did it. In a lot of ways, it's the way it should be done. So he was actually a former supervisor at Amazon. He had significant concerns at the beginning of the pandemic about what was going on with COVID, and he felt that Amazon wasn't doing enough to protect the workers, and tried to get answers for it, and was basically, at least from his perspective, stonewalled. And so he kept asking. Eventually, when somebody around him was sick and still at work, he had enough, and he wanted the building closed and cleaned, and they refused to listen to him. So he organized a walkout, organized some media coverage for that walkout, and then had the walkout with, at least 60, 70 or other people. He got fired after that. He's a supervisor. That's obviously less legally problematic. They said he got fired because he was supposed to be quarantined and he broke quarantine. After they fired him, he decided it was time to organize Amazon and traveled across the country talking to Amazon workers, went down to Alabama, talked to the organizers down there, decided what they were doing was not the right approach. They were too top down, too old school traditional labor. And he said it was much more just about engaging the workers. So he sat out at a bus stop for a year, talked to a ton of the workers at the warehouse he organized, and eventually garnered their support. And successfully organized that location. That is not the traditional way we've been seeing unions do it. He went back sort of to the old school way, just grassroots, talking to people, gathering their support, giving them some gifts, which I think will be subject to some legal challenge here from Amazon, but that's what he was doing, and it was successful. And I think that's the model going forward, because that's effectively the same model that they used at Starbucks. So you're going to see a lot more worker-led efforts as opposed to the big union swooping in and trying to get everybody to sign cards. And obviously, at least in these two high-profile cases, it's been quite effective. So that sort of sets the stage for the environment we're in. And Keith is going to talk to you now about sort of how the government, the most pro-union president ever, and his appointees are trying to make this easier for them still.
So, just to dovetail a little bit off of what Patrick said, right? This homegrown union thing, they're doing what we tell our clients who want to remain without a union to do. They're focusing on employee engagement, right? That's what the Amazon organizer did. He made the connections. He made people feel important. And it's interesting when you listen to that podcast, if you're so inclined, there weren't real big issues or problems. It was mostly about how people just didn't feel like they were part of the team. And so I say that because it's very important to remember that that's obviously the focus of all of our clients who want to remain in a union-free status, or maybe potentially support employees who want to not be unionized. It's that employee engagement, and we'll come back to that. But it's no, mistake. This is intentional, what's happening here now with the NLRB. And earlier this week, this photograph was taken from an op-ed from the Wall Street Journal titled "Rewriting Labor Law by Executive Fiat." And I think that summarizes what's happening here. And the most notable item that we want to talk about today is what happened last Thursday. And then it was, we got some additional information on it this week. But last Thursday, the NLRB's general counsel, Jennifer Abruzzo, who you just saw, basically said, we're going to change the law as it relates to employer free speech. Since 1948, more than 74 years, it's been well understood that employers have a constitutional right, a statutory right to speak to their employees, even on work time, about union issues, about protected activity, right? As long as those discussions, those communications weren't threatening, they weren't coercive, and they didn't unlawfully promise benefits, those sorts of things. Seems reasonable, seems like American, right? We want people to have both sides of the story. We want to have, we don't want to infringe on the employer's free speech rights as well. But in a memo, GC Memo 2204, if you want to read it, just a short 3-page memo, that is going to change if the NLRB's top cop, the general counsel who sets the labor policy, she's the person who brings the cases to the NLRB so that the NLRB can decide whether to change the law by decision. She is asking, and she's filed a brief just this past Monday, to change this law. And what, from my perspective, from when I read this and look at this, really what I see is something, an executive action designed to chill what has been lawful and protected speech for decades, right? And under this memo, generally what it does, it makes it unlawful for you, the employer, to your supervisors, your agents, to speak to employees on work time if that content involves union or other protected activity, right? You can have protected concerted activity for mutual aid and protection that is unrelated to union activity. It could be 2 or 3 people complaining about overtime policy, whatever. But if it involves their statutory rights and they're not free to leave, they have, according to the general counsel, they have a right to leave, to reject anything you have to say, not even to be subjected to it, right? And what the general counsel has said in a brief to the board is, if reasonable employees would understand that the meeting or the discussion, right, the supervisor approaching them might be about the exercise of their Section 7 rights, well, then you have to let them know that it's voluntary, and you have to give a bunch of warning and assurances, okay? And you're thinking probably, well, what the hell does that mean, Keith? I'm not sure I know. I think that's going to be one of the hardest things here is, how do we know when a reasonable employee in the NLRB's view thinks it might involve protected activity? What if a supervisor goes up to someone to talk about some overtime issues, some compliance with safety regulations or work rules? Well, that's perfectly lawful, and you don't have to give them any warnings or tell them that it's voluntary. They got to listen to you. They work for you. But if those employees, or one of those employees that your supervisor is talking to, says something about, hey, Patrick and I think this policy is kind of stupid, does that mean you have to stop and say, hey, I'm sorry, I now have to give you these warnings. I can't talk to you anymore unless you're willing to talk to me because this might involve your Section 7 rights. I mean, it's so stilted. It's so ridiculous in my view. But nevertheless, that's the position that the NLRB is taking. And it's broader than just union organizing, right? As I said, it's just protected activity. But also, if you are a unionized employer, right? Well, what's protected activity? A grievance, right? If I get together with Patrick and we file a grievance because we don't like the break policy or the new work rule, if you're having discussions about grievable topics, do you have to give those warnings now? Arguably, you do, if this gets adopted. So go on to the next slide, Patrick. We'll talk about what it does specifically. Okay, and we know this now because we have some more detail from the NLRB's general counsel. She filed a brief asking the board to change this on Monday, and obviously it'll get litigated. It'll take some time, but there's really 2 areas that she identifies or focuses in on when these voluntary assurances must be provided, when it will be unlawful for you to talk to your people unless you give them a warning that they can walk away or they can, go back to work. The first is when employees are forced to convene on paid time, right? Convening on paid time, we'll talk about in the next slide, but basically your traditional captive audience speech, right? If you call a meeting in the break room with the maintenance department, hey, everyone needs to be there, we got to talk about some stuff. You're convening your employees on paid time. That's one area. The second area is when your agents or supervisors, quote unquote, corner the employees while they're doing their jobs, right? If they're on the line, if they're on the floor at the hospital, and your employee and your manager or supervisor wants to talk to them about something, they're going to be in a situation where they may have to give the warnings if what they're going to talk about is going to involve union activity or other protected concerted issues. Okay. And this is a quote directly from the NLRB's brief, or the General Counsel's brief to the NLRB. An employer has convened a captive audience meeting when it asks employees to attend a meeting on paid time without providing the assurances. And then they're cornered when the supervisor or someone approaches them while they're performing job duties. Okay. I think it's important to remember that the General Counsel has to ask the board to change the law. So technically, she doesn't have the authority to make the law by fiat. However, practically, we all know what that means, right? If she's making the law, she's saying, if you do this, then I'm going to issue a complaint and then you're going to have to litigate it, right? So even though it may not be the law and the board may reject it, I highly doubt it. I think this is all coordinated, and I think the Biden majority NLRB is going to make these changes. What a federal court will do with it, I think, is less clear, and I think we're going to have to wait a few years before we get that decision. Go ahead to the next slide, Patrick. All right. So what do I have to do if I want to comply? Let's say you want to comply with this because whatever, you feel like you want to, because you don't want to have the government breathing down your neck. You don't want to have litigation costs. What would you have to do to comply with the General Counsel's view, what she calls sensible prophylactic safeguards? First, for convened employees, right? So if you have a meeting and you order people to come to a meeting, you must explain the purpose of the meeting, both in your announcement, right? So if you say we're going to have a meeting at next week, you have to explain the purpose at that meeting, and then when you convene the meeting itself, that on Monday, you have to reiterate the purpose. You have to tell employees why you're meeting with them, and if that's to address some protected activity issues or union organizing, you have to tell them. Then you have to assure the employee that their attendance is voluntary, that they're free to leave at any time, that non-attendance will not result in reprisals, in other words, like loss of pay or any other harm, and that their attendance will not result in rewards or benefits, right? We're not going to reward the people that come listen to the speech, okay? And the reason that the General Counsel says that this is unlawful is because she has determined in every case, this is not a case-by-case analysis, in every case that there is a threat of reprisal, that it's unmistakably present whenever an employer requires employees to listen to the employer's message concerning Section 7 rights. So she is basically saying there's a blanket anytime you talk to your employees about anything impacting the union or their Section 7 rights, you're inherently coercing them. You're inherently bad. You're inherently evil people. Sorry for the bad news this morning. So for cornered employees, very similar warnings if you want to follow the guidance. You have to explain the purpose of the encounter. So Patrick's my supervisor. He wants to come up to me. Patrick better tell me why he's coming up to me if it has anything to do with my protected rights. And then he's got to assure me, again, my participation is voluntary. If I don't participate, it's not going to harm me in any way. And that participation, if I do talk to him, I'm not going to get any rewards or benefits. And this last bullet point on the right column here is particularly troublesome to me. You have to get affirmative consent to talk to the employee, right? And then you have to tell them they can end the encounter at any time. I mean, who's in charge here? So the supervisor, Patrick, comes to me, says, hey, Keith, I need to talk to you about some stuff. Well, he's now, I'm on the clock. He's got to get my consent to stop working and talk to him. It's just, it's an odd structure. Again, it changes, 74 plus years of precedent. All right, next slide. Okay, so let's talk a little bit in the closing minutes here about the impact that we see this having. Well, first, in the union organizing setting, right, it's going to be huge. Because if you have organizing going on, or your guys are being targeted at a construction job site, or you got a union organizer sniffing around your parking lot at your plant or your hospital, right? If your managers talk to people about union activity and they don't give these warnings, under the NLRB's view, you violated the law. Okay, you say, great, but we don't care because it's not the law yet. Well, it could apply retroactively. And if it does, you're going to be found to have violated the law, and then you could win the election. Let's say you have a union election, but your supervisors are exercising their First Amendment rights of the employer. Now that's unlawful. Now you got to have a rerun election. And you say, okay, well, that's fine because the union's still out. We exercised our right. We have a right to explain to the employees lawfully why they shouldn't choose the union, and they didn't choose it, so we'll have another election. So great. Well, that's where this double whammy comes in, as I call it. The NLRB's general counsel, in the same brief filed this past Monday, is asking the board to bring something back that's called the Joy-Silk Doctrine. The Joy-Silk Doctrine is basically a form of card check recognition. Right now, and as the laws existed since the late 60s, under a Supreme Court decision called Gissel, is employers have a right to say, hey, if our employees want to sign union cards, it doesn't matter if over half of them, a majority, sign union cards, we have a right to request a secret ballot election. And we request that secret ballot election, and we win or lose. And the only way, under current law, that the union can be imposed on an employer is if there was 50% or more than 50%, a majority of employees had signed union cards, the election goes in the employer's favor, but the employer engaged in widespread, significant, egregious, unfair labor practices, right? You acted so poorly that the law and the board can impose a union bargaining obligation on you, right? So if you run around saying you're going to fire everyone, you're going to close your facility, those types of things, and that makes sense, right? If you're just a scofflaw and you're not trying to exercise your First Amendment rights, you're just threatening, you're promising, you're violating the law all over the place. Okay, if Joy-Silk Doctrine returns, if a union gets a majority of your bargaining group, your employees, to sign union cards, they present them to you, and you say, I don't want to recognize you, union. I want to have an election. I want to make sure my people, our employees, hear both sides and they can vote, and it'd be a secret ballot. That's the preferred method, has been for decades, for employees to decide what they want. Well, now, if under Joy-Silk, if that gets adopted, the employer must prove that they had a good faith doubt about whether the majority really supported the union. And the real whammy here, as I see it, is if you have an election and you claim a good faith doubt, if you violate the law in any way, they can impose the union on you, right? You don't have to have severe, widespread, unfair labor practices. The fact that you broke the law in any way could be used as evidence to show you didn't act in good faith, and therefore we're going to impose the union on you no matter what the election results. That's scary. What about the impact in the decertification setting, right? If you have employees that want to get rid of the union, well, now you have to be super careful, right? Because, if your supervisor does what we've trained supervisors to do, what other law firms have, here's the law. You can talk to your folks, right? You got to do it in a non-coercive way. You're not going to promise them things unlawfully, but you can share your opinions, your views, your examples of why you think it's not a great idea to be union. Well, if you do that, and the NLRB comes back and says, well, no, we're not going to have an election because we think you violated the law, or we're going to have an election, but if the union loses, we're going to have a rerun, right? You could see, why having this be a violation of the law is designed to muzzle employers, to give the union an advantage one might argue because they can't win the battle of ideas. We got to tilt the playing field. Same for unionized workforces, right? I mean, it's probably less of a concern in that area, but if you have unionized workforce and you have folks you want to talk to about general things, if it implicates Section 7 rights, this could be an unfair labor practice. So bottom line here, the takeaway for me, folks, is it's really going to force employers and organizations to make a choice, right? You're going to have to decide, are you going to comply and give up your speech rights, right? Even though the law hasn't changed yet, are you going to give up some of those speech rights because you want to be on the safe side of this? Or are you going to say, you know what, we're going to continue to exercise our lawful rights until the law actually changes, but that might bring a complaint against you, result in litigation costs, right? The 800-pound federal government on you. I don't know how big your organization is. Some are bigger than others. Some can afford it, some can't. And then really the negative impacts on union organizing, right? What if you don't speak up because you comply with this and you lose a union election? Or do you speak up and you risk it? And certainly, those are the two polar, the two poles of the choices. And there's lots of room in between. We can certainly talk with clients, and we've already done so with a number of our clients about, how do we, maybe hedge our bets, maybe comply a little bit, maybe give ourselves the best protection. And that'll all depend on the specific facts and circumstances that you face. One more slide, Patrick. All right, so what should we do about this, Keith? That's great. You told us a lot of terrible stuff today, this morning, but what should we do about it? Well, I don't have all of the answers, but some general guideposts here, right? Look at the facts and circumstances, right? Talk to us, talk to you, whoever your labor relations folks. If you don't use us, whoever your labor lawyers are, what are your facts and circumstances? What are you most concerned about? What are the risks and what is most important to your organization? Is it remaining union free? Is it, hey, we're in the middle of a case. Hey, I don't think our guys have and gals have any interest in a union, and so I don't want to have to deal with a ULP charge. What are your individual facts and circumstances? What is your organization's risk tolerance, right? Are you willing to fight for your rights if you have to? And get specific advice. I think the most important thing that I think you should do is this fourth bullet point, is evaluate your employee engagement efforts level of success now. Frankly, it might be better to say we should have done it already, but certainly do it now. Do it before the union comes sniffing around at your folks, right? Because once they're on the scene, then you're going to be in the spotlight, you're going to have a target on your back, and the things that your supervisors do are going to go under scrutiny. And so, whereas if you can have strong employee engagement, like the organizers did at Amazon, and you get the hearts and minds of your folks, then maybe the card signing never occurs, or it certainly never gets to that 50%, which could really get you in trouble if Joy Silk becomes the law. So, and the last thing I would say here is, consider supporting challenges. You're all part of different organizations, business groups, associations. Make sure people understand how ridiculous and outrageous this position is if you agree with that. I mean, maybe you don't, but if you do, and this is about free speech rights. This is about tilting the playing field, and it is. I don't think that Wall Street Journal op-ed is far from the truth, and I kind of agree with it. It is a little bit of executive fiat here, right? What's going on here? And there's going to be opportunities, I'm sure, to file maybe potentially amicus briefs, as well as maybe other legal challenges. So speak up, get involved, and consider supporting challenges. Next slide, Patrick. All right, questions. I've got a couple here that, and I apologize, we went a few minutes over, but I'll answer the questions here, or Patrick and I will tag team these questions, and then If others want to type them in, feel free. First question is, do you also think Joyce Silk will be agreed to be reimposed by the board, as you do think the captive audience rule changes will be agreed to? So good question. So I think potentially yes. Interesting with Joyce Silk, it used to be the law for, I think, since 49, from between 49 and like 60. And during the Supreme Court decision in Gissel, the general counsel's lawyer said to the Supreme Court, yeah, we don't look at good faith anymore, so we don't really consider it. So the NLRB has already anticipated that the argument that no, the Supreme Court has foreclosed this, and they're going to argue, no, the Supreme Court didn't address it. And it existed for decades before Gissel. And so we have deference and discretion to adopt this. And so I think the board, to answer the question, the board is likely to adopt some form of the Joyce Silk doctrine. Whether a federal court will enforce that, it may not. I think it's going to depend on what court you get, who the judges are, and what their view of the deference to the NLRB's rulemaking authority is. So good question there. One other question. Will an employer have the ability to penalize employees who voluntarily leave, convene meetings, or end a cornered meeting? Okay, absolutely not. If you penalize them, that will be unlawful. And in fact, what the NLRB's general counsel says is, look, they fear it automatically. There's just an inherent fear that if they tell you they don't want to listen to your message on union organizing, that's going to harm them. It just exists, whether you intend that or not, whether you actually would penalize them or not. It just exists based on the circumstances. In other words, you're ascribed evil, improper motives just because you're asking them to listen to you without telling them it's voluntary. So, but yep, definitely cannot penalize folks under the NLRB's view. Now, under current law, right, if it didn't change, you certainly could say, no, you're directed to go to a meeting, and just like every other meeting, you got to be there. And if not, you can get written up. And one other, I guess, follow-up here would be, when I mentioned federal courts, right? How does that get challenged? So the NLRB has this brief from the general counsel. There'll be opposing briefs. Hopefully, business groups, associations will get their oar in the water. Will file some amicus briefs. If the NLRB changes this law, they'll do so by decision. That decision then can be appealed to the federal Circuit Court of Appeal. So a federal appellate court will likely resolve this, and they'll determine whether the board has acted consistent with its authority granted to it under the National Labor Relations Act. Okay, where that will happen, it could a number of places. One, there's an absolute right of appeal of a board decision to the DC Circuit Court in Washington, DC. So that's one district federal appellate court that could resolve this. Alternatively, wherever the alleged unfair labor practices have occurred, so whatever state, whatever jurisdiction, so it could end up in any other federal court around the country, depending on where the NLRB underlying facts giving rise to the unfair labor practice occurred. Is there some possibility of a federal district court challenge to maybe try to enjoin this? I think there may be. It's beyond the scope of this webinar, but I think there's some significant jurisdictional arguments that would have to be overcome there. And I think maybe some federal courts may view this as something that just should be resolved through the administrative process, which then can be appealed to the federal appellate level. But that doesn't mean that there is not a factual basis for irreparable harm and a potential injunction here. That is a possibility for sure. It's just not something that we've fully vetted or that I can comment further on today. Okay. One other question here, and Patrick, I don't know if you want to take on this question. I'm sorry, I've monopolized the time. For those of you that know me, you're not surprised. What are the constitutional issues, if any, regarding free speech and content regulation?
So Keith, I would say, the First Amendment is, to some degree, it's written into the National Labor Relations Act under, it's called Section 8C of the Act, and it basically gives employers the right to disseminate their opinions to employees. And so to the extent there's constitutional issues here, they are wrapped up within the act itself. And so that is certainly going to be one of the arguments that's made here, is that, look, these captive audience speeches or cornering, right, without some other unlawful conduct, we are just exercising a right given to us by the Constitution and by the National Labor Relations Act. And I don't know what the court will, or the board will do with those arguments, and certainly what a court will do with those arguments, but those are things that are going to be raised and argued. And I personally think, and I know Keith does as well, that it's a very good and important point.
Yeah, and if I could just maybe follow up a little bit on that, right? I mean, right now, and in Section 8C of the Act is what mirrors the First Amendment, right? And the Supreme Court has told us in Gissel that the 8C incorporates the First Amendment principles, free speech rights for employers. That 8C language, at the end of it, it has a carve out that says, look, you can't do this if it's if it's threatening, that sort of thing, right? And so I think where a ripe challenge to me would be is, look, this is not a case-by-case analysis where you're looking at facts and the board is deciding under these facts your speech is coercive, right? This is a blanket rule that to me is arbitrary and capricious. To say that every time an employer exercises their speech rights while the employee's on work time without giving specific assurances, I think might be, I think arguably it is a violation of your free speech rights. You're not even giving me a fair shot as the employer to look at whether I'm actually coercing or not. And so I think that sort of, facial rule, rather than looking at a case-by-case analysis, may bear fruit. The other area I think in terms of constitutional is there may be an argument that this is, restricting speech, right? In terms of before it's even said, right? It's a prior restraint is how we would say that under constitutional law analysis. And, if it's overbroad and reaches otherwise lawful speech, and it chills it, the government is chilling it before it even happens, that may be another area where a challenge could be presented on a constitutional level. And just one real quick follow-up to my answer on the question about, can we penalize someone if they tell us they don't want to listen to us? They absolutely have to go back to work, right? The right to not hear the employer's message under the GC's memo does not include their right to leave work, right? You just have to leave them alone, just go back to work. They don't have a right to stop working and leave. So just to be clear on that. Thank you all for taking time this morning. And I'm sure if you have follow-up questions, if you have specific issues that you want to address for your organization, feel free to give me, Patrick, or your Miller Johnson lawyer a call, and we can walk through and talk about how it applies to your specific situation anytime you'd like. So thanks again, and have a great day.